All right, good morning, everyone, and welcome to another edition here of our Justice and Pieces guest speaker series. And today we have a mediator, and he can tell you a bit about his other experiences. Thank you very much, Andrew Clarke, for joining us.
Well, you're quite welcome. So I'll launch into an introduction of myself, and I have just a couple opening remarks before I open it up to questions, and I hope you have lots of questions, but I'd like to start off by thanking John, Paul, Christopher, and Rochelle for inviting me and organizing my involvement in this series with you. I'm very happy to speak with you today, and if you come up with a topic in the future for our next group of students in the next cohort, feel free to get in touch and ask me if I can help, because I'd be very, very happy to do so. I'm Andrew. Please call me Andrew if you have questions. I don't really need the Mr. Clarke. I'm trained as a lawyer. I was called to the bar in 2003, and I practiced in insurance defense for the most part. So that meant largely car accident cases, so auto cases, occupiers liability, so your slip and fall type cases, product liability, fire loss, water loss. And early in my career, I did some medical malpractice when I was at one of the first firms I was at after articling. Starting in 2008, I branched into mediation, and that's all that I'm doing right now. I'm quite enjoying it. And most of the mediations I'm doing are similar to what I was doing when I was in practice, and that's largely car accident cases, occupiers liability, and we had a little bit of construction type work as well. You can ask me more questions about my background if you wish as we go on. But the prepared remarks I have, or the notes that I took down, are about two things. One is reputation. The second is the role and value of mediation. So we'll start off with reputation. Your reputation is one of your best assets, and your reputation starts during the program that you're in right now with your colleagues and your peers. It is entirely within your own control and can be easily lost. You have a duty to your clients and to the legal community to be ethical, and I'd suggest reasonable, trustworthy, and always honest in your dealings with your peers and your clients. I hope that's a non-starter for everyone involved in this program. Having a good reputation makes your work easier. And once you lose your reputation, it's frankly lost, and it will make your job harder. It'll make it harder for you to represent your clients and to do the best for your clients. And in the context of mediation, if you have a good reputation with your peers and your colleagues, it makes your job a lot easier. Now I'll move on to the second very brief prepared remarks I had about the role and value of mediation. When I started as an articling student, mediation was pretty uncommon, though they'd started up the project of mandatory mediation in Toronto, Ottawa, and Windsor. But by the time I had my own files, mediation was pretty firmly established as an integral part of litigation. And from my perspective in litigation, it was not just a mandatory step, but a very valuable step. As litigators, trying to figure out how to express this properly, there are few opportunities for advocacy. Examinations for discoveries are one, but that's an evidence gathering process. Trials are extremely expensive, and they're quite rare. When I was articling, there was a woman who I thought was a senior associate. She was about 5 to 7 years out from her call, and I was shocked to learn that she had not had a trial. Well, once I started to get my own files, I started to understand that, well, that wasn't so uncommon, because trials are unbelievably expensive, and you want to try and resolve a case before trial, if at all possible. That may be a little bit different when you get into small claims files. I don't think I ever did a mediation in a small claims file, and I don't know if that's changing. But mediation is an excellent opportunity to advocate for your client and try to resolve the case before you incur additional expense. And quite frankly, some cases are never going to resolve at mediation, but the mediation can at the very least narrow issues or help you in your advocacy, to understand better what the approach of the other side is towards resolution. Those are all the prepared things that I have. And in line with what John Paul said earlier, please don't be shy. For this purpose, no question is a stupid question. So have at it.
All right, so maybe I'll start so that students can think of some other questions of their own there. But how was it like maybe being on the other, or not necessarily on the other side, but like the neutral third party now, rather than now? Do you have experience doing mediations as a representative for one of the parties first, and how do you compare the roles?
Okay, so as I think I mentioned, once I had my own files and I was running litigation files, it was more common than not to have a mediation in the case. And so it's the difference is obviously you're advocating when you're counsel for a party. What's different now is seeing what's going on in both rooms. That's a big change. I always had suspicions about what was going on in the other room. You know, like, why did it take so long to get an offer from the other room? What were the internal discussions going on between one counsel and their client? You know, we'd have suspicions, but we wouldn't necessarily know. What's also interesting for me, and this ties into the theme of advocacy, is I only get, as a mediator, I only know about your case what you give me in your brief. So having practiced for long enough, when certain documents aren't included in a brief, for example, if you have a car accident case and no one's put in the property damage file, or one side puts in the property damage file and the other doesn't, say you got a defendant, they don't put in the property damage file in their case, I kind of scratch my head for a second and realize maybe the property damage file does not help the defendant. Because if it did, and it was a relatively minor thing, they're going to throw that in there. Same thing with other medical records. If you don't have a decoded OHIP summary in there from the plaintiff perspective, does that maybe key me in or hone me in on the fact that maybe there's an awful lot of health issues going on before the accident or after the accident that aren't related to a car accident? So it continues on with what I thought of my role as a litigator, which was as an investigator. You know, you're trying to figure out the picture of liability and damages, contractual issues, and you're trying to pick in little bits of information to better understand the file. So when I get a memo from a party and things seem to be missing, that's as loud to me as things that they put in.
Now, what in terms of advocacy, then, so maybe let's talk a bit about your experience there advocating in mediation. How is it different than advocating in, let's say, a trial? And I think that the biggest mistake I often see students make is that they're like in trial mode during mediation, and it's very it lacks the collaborative efforts that I think would really draw upon a resolution. So, what can you share about how that all works?
Oh boy, that's a good question. I'll answer it initially obliquely and then try and be a little bit more specific. I had the benefit of a really good mentor years ago. His name was David Little. He became a judge. He's now passed away. And at a CLE event that he was one of the speakers, he told us that you have to forge your own way in terms of your own personality, your own approach. And this was important because he was a rather, I wouldn't say flamboyant, but he was unique in his advocacy. He had a certain flash, and people would want to emulate that. But he made the point, you have to figure out what works for you. And so sometimes I think maybe if you get into a trial mode at a mediation, that can help, but it could hurt. But mediation oftentimes is about, well, there are different things that you can get out of mediation. One can be it's an opportunity to speak directly to the other decision maker. Defense counsel gets to speak directly to the plaintiff. Plaintiff counsel gets to speak directly to the defendant or the defendant's representative. That's a unique opportunity about mediation. The soft sell can be a little bit better, like just speaking directly to the person about what their weaknesses are and what could happen at trial. So getting back to what I mentioned initially, goes down to your style. Like if you're trying to, at a mediation, express to the other side, like trial is not going to be as good as you think it's going to be. You're imparting some realism. You're imparting some of the risk of trial. That can be helpful, but it's all contextual. It may depend on what's the other side like. How's the other side been to deal with up to that point? But mediation, I think, is really dealing with it's the opportunity to deal with the opposing decision maker. Because John Paul, if you and I were opposing counsel or opposing representatives on a file, by the time we get to a mediation, you and I have had a lot of discussions. There's been a lot of correspondence going back and forth, but I have not had a chance, more than likely, to speak to your client. So at the mediation, your client is my audience, and to a certain degree, you are as well. But this is my opportunity to speak to your client, and I'm going to make the most of it.
Now, when you now put on the mediator hat, what type of style of mediation? Students learn about like facilitative versus evaluative. How do you kind of decide that, or do you have a certain sort of stance coming in, or does it depend on if the parties are represented, or how does that all work?
Oh, another big, difficult question. In the area of insurance defense, like if you've got car accident cases, you got occupiers liability cases, when it comes down to it, at the end of the day, they're looking for a monetary amount. They're not looking, it's not an interest-based mediation, though interest may play a part. And I'm not sure if the focus in your course has been on interest-based or if it's been on, or how it's been. But at the end of the day, in most of what I do, people are looking for a certain dollar amount. And so the facilitative versus evaluative, my approach tends to be a bit of both, because if one side is, pardon the expression, completely out to lunch, you need to help them rein in on that and be a bit more realistic. But I don't want to interject myself as a decision maker or interfering with counsel's role as counsel's role in helping them to advise them on what the likelihood is. I don't know the case nearly as well as counsel, so I don't want to interject myself too much. Now, okay, so we've got a question that came in. Once you get a file or case for mediation, how much work do you need to put in for mediation to be successful? Like in your brain, do you need to figure out the BATNA and WATNA for the case? No, I don't need to figure out the BATNA or the WATNA myself. That's something that counsel needs to do. I can try and help guide them, but I don't find that I'm ever bringing that terminology up with counsel or the clients. I might help them, like in terms of talking about, okay, so if you don't resolve today, what's going to happen in the future? Are you going to have to get medical legal reports? You're going to have to get more medical records? Are you going to have to get more financial records? What may happen if you get those records? You don't really know what's going to be in those records. Is it really going to help your case? But then subtly putting in part of the WATNA is, okay, so if you do not settle today at this mediation, you're probably not going to have trial for 2-3 years. That can have an influence on people. So my preparation for a mediation, continuing on with a question from the text from Hunar, is I read absolutely everything that comes to me. I want to understand the case as well as I can from what they've provided to me, including what I mentioned before about what seems to be missing. I hope that answers your question, Nora.
And so you mentioned a little bit of reality kind of testing, right? That, well, hey, if you don't resolve here, here's what you could be looking at. How often do you think that kind of gets the parties more back to the table instead of maybe posturing about their positions, or how does it work?
It varies. It depends on the counsel. It depends on the client. Some people may not be concerned that it's going to take a long time. It's all very contextual in terms of, and sometimes I won't know, because I find with a lot of what I'm doing, I'm not having heart-to-heart conversations with decision makers or plaintiffs, the plaintiffs themselves, about what they need out of this, or their motivations. So not all the time, sometimes, but I hope that answers your question, John Paul.
And so the students learn about caucusing, and how effective have you found taking them to like a breakout room, I guess, on Zoom or in person, like one of the other rooms at a place like Network North? How does that work, and when do you kind of employ that?
A lot. I think most mediators that do personal injury mediations, after opening remarks, everyone goes into a caucus room. It's different from the interest-based mediation that you may have been exposed to in your program. The course that I took at York really focused on interest-based, where you only relied on a caucus kind of as a last resort. You wanted to have everyone talking in the same room all the time. The personal injury bar, plaintiff and defense, has, I think, adopted early on the idea of, after you have your openings, you just separate and you go into a caucus. And I think the value of the caucus, before I get there, rightly or wrongly, that's what the personal injury bar has been doing, or the insurance bar, in terms of construction law cases, that kind of thing. You separate out after those opening remarks, and I'm not sure if that's good or bad, but in the caucus, if people speak freely during the openings, they speak even more freely in caucus. And it just seems to be what gets done. Like you break into caucus, you have conversations, people can cry, they can yell, they can laugh, and then you go back and forth with messages. I've found that people don't want to have more difficult conversations directly in front of the other side. If you can speak a bit more freely when you're in caucus, if that makes sense.
And then how much of that stays private, or do you go get their permission and say, okay, I want to take this over to the other side in their room, or is it a mix of both, depending on the matter?
You have to be cognizant as a mediator as to whether or not what's being said in caucus is private or can be used. And a lot of mediators at the outset of their mediation, in their opening, before they hear from the parties, will say something to the effect of, when we're in caucus, anything you say to me is fair game, unless you tell me I can't use it. I personally don't like that approach. I want parties to be more explicit about what I can say to the other room. I really like in caucus when the parties open up to me about motivations or concerns, and then say, but keep this between us. It's still in the back of my mind that I understand what's going on, what those motivations are, what those concerns are. I just don't give voice to them. It's both an ethical issue and a trust issue with counsel. Like if you tell me something that's in confidence, I keep that to myself, though I can use it internally. Does that make sense to you? Or should I expand on that?
Right, and I think part of that then also is what happens with respect to, obviously there's various duties of confidentiality, but if things don't end up resolving,
Yes.
how much of that sort of now is in the back of the mind of the parties of, well, if they go to trial, what, they have all this information, I mean, that they can't explicitly use, but they can sort of have in their back pocket there.
Well, um, if you learn something as an advocate, as a representative, as counsel, if you learn something at mediation that you can't otherwise get into evidence, it can inform your trial strategy. It can inform your negotiation strategy going forward. But you can make requests like of the other side, for documentation. So say you learn at mediation that the plaintiff has a new health concern that hasn't been disclosed. Like I had a mediation years ago where, as counsel, I learned that one of the plaintiffs, had been diagnosed with a very serious cancer, and that factored into our negotiation strategy. Well, not just negotiation strategy, but this plaintiff was looking for a considerable amount for future pecuniary claims, so income loss, housekeeping, home maintenance, those types of things. This person, by learning that they had cancer that was 95% likely to result in their death within 6 months, that changes the math. And so after the mediation, we requested updated medical records. So you learn about it that way. If it is truly something, though, that you are not going to learn about, you can't use it. It's like settlement figures, like you can't use those later on. You can't say during trial when you're on the stand, but the defense offered me $50,000 at mediation. You got a mistrial right there, as an example. Does that answer your question? To a degree, if you want me to expand on it, if you have something to clarify the question, I'm welcome to.
That's perfect there. And I see a question here from Kevin. Yep. How do you stay unbiased or neutral in the mediation process?
Poker, it's tough. If a party is being unreasonable, I just have to do my best. If a party is just not making sense, I have to do my best. It can be difficult, but you just have to put on a good poker face and do the best you can. And I think the trick to being unbiased or neutral is to be aware if you're being biased, or if you're becoming less than neutral, and then being conscious of the fact. Does that make sense, Kevin? Maybe Kevin won't answer.
So with that,
okay, good. It does.
With your background, I guess, is it almost exclusively you were doing insurance defense, or were you ever on the plaintiff side at all before going into mediation? Or
I did not act for injured plaintiffs. Sometimes insurance companies would do what's called a subrogated claim, where you would be retained by an insurer to pursue another party for the damages that the insurer paid for. So that was my exposure to plaintiff work. Yeah.
So having that background, well, maybe first let's look at it this way. What brought about the decision to go into providing mediation services from the insurance defense side?
I was not happy with my last position. And so I decided to leave that job, and mediation seemed to be a good fit. Because when I mentioned earlier, in terms of personalities, you have to figure out your style. You have to figure out what works for you personally. My practice, typically I got along with people. It was rare for me not to get along with opposing counsel or co-counsel, and it was a good personality fit. And at the time that I left that position, there was a contraction of private positions, so like positions in law firms, and it switched more to in-house departments. And so there were fewer positions for more people. So it was good timing, I think, to get into mediation.
So with that background then in insurance defense, how we were talking about being neutral and unbiased, but so now you find yourself mediating between representatives and on the personal injury side, right, the plaintiff side, and then your background in insurance defense. So how much do you kind of, and I think we see this sometimes with in criminal law where judges come from the criminal defense bar and some come from the crown attorney's office, and how much do you think that plays a background in when you're looking at a dispute and you're saying, well, if I was counsel I would be doing it like this, or I would be thinking this is more of an issue, or how much of it is if on the plaintiff side you're thinking, well, you didn't really present some of the documents that are needed, or there's something here. It may be just something of like nuisance value, and you're really trying to pull the wool over everyone's eye. How does that factor in?
Well, as in my role as a defense lawyer, my job wasn't to blindly pursue my client's interest. I did a better job representing my client by being objective about the strengths and weakness of my insured's case. Because if you don't recognize pitfalls in your own case, you get into trouble later on. So I would provide unbiased assessments to my client about the merits of their case, what was good, what was bad, what was iffy. And I think that continues now, because when I'm reviewing for a mediation, I recognize when there's a weak argument from the defense. I recognize when there's a strong argument from the defense. I also recognize when there's a weak or strong argument from the plaintiff side. And it's not uncommon in the personal injury bar, for example, for counsel to switch from one to the other. And I've got a good friend who started off defense, went plaintiff. He was very successful as a plaintiff lawyer. He did an excellent job for his client, and in part because he maintained that objectivity about what was good and bad about his client's case. And then he made the switch back to the defense. So if you're not being objective about the strengths and weaknesses of your own client's case, you're doing them a disservice. And so I think that just continues on in this role as a mediator, of objectively looking at the strengths and weaknesses of each side's case.
Someone's asking, maybe this goes back to when you were preparing for mediation or negotiation, even with the opposing counsel. How much time do you prepare for that versus the actual length of maybe a half-day mediation or a half-day negotiation setup?
Right now, I probably spend more time than I should preparing. I think I'm spending far more time preparing for a mediation than I'm actually spending in the mediation. Most of the mediation sessions are booked in 3-hour blocks, and it's not uncommon for me to take about 2 hours reading the brief of each side, depending on how much productions they send me. So, for example, today before we got on, I started looking at a file that I have next week. It's 2 plaintiffs. The memos appear to be about 15 to 20 pages each. And one plaintiff, there are 9 tabs. I haven't yet seen what they are yet, but assuming each one is between 5 and 10 pages, and some are going to be longer than that, that's a lot to read and a lot to process. So it depends on the case. But I'm at this stage, I think, over preparing, because you got to remember, as mediator, the only thing I'm going to know about your case or the party's case is what they actually send me. So it'll take as much time as it takes to read through everything and to properly evaluate what they've sent me.
Now we're talking at the outset here about mediations happening on platforms like Zoom that we're on right now. So perhaps maybe you could give us some insight, because the students have to adapt to doing things now, mock trials and things on an online platform. What's the difference between running mediation on Zoom versus running it at a center or in person somewhere? What have you found?
All right. So I prefer in person, and I'll try and rhyme off some of the reasons why I think in person is better. One is body language. When you meet the parties, you get a better sense, I think, of who they are, because right now I can see Adam, and all I can see is Adam from his upper shoulder to the top of his head. Adam appears to have had a haircut in the last couple of months, and he has a beard, and that's about all I can gather from his physical appearance. I'm going to stop talking about Adam now. When I meet a plaintiff, when I meet a defendant at a mediation, I can get a better sense. So, for example, I hope no one takes offense to this, but when you meet a person, you get a better sense of how they are and who they are. I had a great mentor when I was starting out in this, and she made the point that when you have an examination for discovery, for example, of a woman, have they done their hair? Have they put on makeup? Have they put on jewelry? How are they dressed? Are they cleanly dressed? And this goes for men as well. Like, when you meet someone, have they taken care with their appearance? Do they care about themselves? You have a handshake. Is it a limp fish or is it a strong, firm handshake? Is there confidence in their handshake? If you've got someone, for example, and this is going beyond mediation, but evidence gathering as well. If you're meeting, a 45-year-old man who says that he's a laborer and he hasn't been able to work since the car accident 3 years ago, you shake their hand and they've got calluses and they've got grease under their fingers and they were a mechanic before the accident, maybe they're still working. So you gather more from meeting with people, but I think you also, beyond that information gathering, you get a better sense of the person. You develop some rapport. If you're staring at a TV screen or a computer screen, you're not getting that connection with the person. So those are some very specific things and maybe some general things about why I prefer in person that you lose when you're on this platform. But we have to adapt and overcome. We have to adapt to changing situations. And as you and I were talking about before the session truly started, John Paul, this may be the new reality. You mentioned, why would people, go back to going to network, for example, when, you can avoid that as expense. In chatting with plaintiff lawyer last week, 2 weeks ago, he was like, I don't think I ever want to go back because for my mediation, I just log in. I don't have to drive. I don't have to put on pants. He's wearing shorts. I don't have to drive for an hour and a half to get to network. I don't have to pay for parking. I can go from working on another file to mediating, and when the mediation is done, I go home. Or like, I'm already home. I don't have to drive anywhere, and you don't have that additional expense. So there's benefits to doing Zoom in that respect, but I think I have to work a little bit harder to get that rapport. I'm going to miss out on those body language cues. I'm not going to be able to have that same opportunity to speak directly. Well, I can speak directly, but I never did video dating. I never did online dating, like where, like you're trying to connect with someone online, before you actually meet them. Meeting people is better. Interacting over a computer is different, if that makes sense. It's different, but yeah, you just have to adapt to it.
What about in the actual, let's say, mediation itself, in terms of maybe having control of the process of, having to mute people maybe versus, whereas in person you'd be like, okay, I'm going to hear from them, or caucusing on the sort of breakout rooms. How have you found that?
I find it's faster because when you go to a place like Network, I'm not sure if your colleagues, your class have been to a place like Network in your studies, but Toronto has this unique company called Network, and so if I'm over explaining, because you've all been there already, I apologize. But one of the dynamics of a place like Network, with their 3 locations, is that they cover an entire floor of an office building, and they accurately named their business before they started, because they've got this nice kitchen where when you're on a break from your discovery, you can go and have something to eat. You can network with other counsel, and that's kind of a problem sometimes in a mediation where you're trying to find a party. When I need to reach someone in a caucus, I just join into the room and they're there. I don't have to go looking for them. People don't disappear for 15, 20 minutes at a time. And sometimes as counsel, I had mediators that kind of just disappeared. Like, where's the mediator? I don't know. Let's go check the chicken kitchen and see what they're up to. So I find that the Zoom mediations can actually move a little bit faster. Like not all the time, but they can move a little bit faster. There's a bit more efficiency. I'm not just standing in a hallway, and I think there's some benefit to counsel, and maybe this is not a good thing for mediation, where during downtime when I'm dealing with the other room, they may be doing work at their computer. They're not focused, because I think one of the benefits of mediation is that you're focused on one file for that period of time. Does that answer your question, Jean-Paul?
Yeah, I think
anything clarify?
Makes a lot of sense, that you have more efficiency, less distractions, right, at the location itself. Any other maybe quirks that you've noticed with doing it online, like any other issues that you found?
Yes, and then I'm going to answer Vivian and Adam's questions. One of the quirks that I find is it was something that I think a lot of lawyers have difficulty understanding, which is not everyone has a smartphone. Early on, I had a mediation, like once all this Zoom started, we had a mediation that fell apart because plaintiff's counsel called me up, and the defense counsel said, I just learned that my client does not have an internet-capable phone, iPad, or computer. All right, would your client wish to participate by way of a conference call in with you? It was like, no, I think she needs to see. I think she needs to see the parties. So socioeconomic factors have played a role, and technological ability. I hope it's not ageist to say, but some demographics have more difficulty with technology. And so there have been mediations that have been derailed or complicated because a party couldn't figure out how to log into Zoom. So that's one quirk, I think, that technology is great until it isn't. And that's one of the benefits of being in person, is that you're not reliant on a network going down, Wi-Fi cutting out. Fortunately, so far, I have not had a power outage at my house while I'm doing a mediation, because that would really suck. Vivian, I don't think it would hurt to get a certificate. I could have just launched into mediating without the program, but I think it really helped me focus in on getting a mediation mindset. And I think having some formal training in interest-based mediation and having to practice those skills of being a mediator, even with my classmates, in sometimes some kind of funny scenarios, really did help, because you get to practice, you get to develop a bit of a network. I take it that the program that you're in right now is more the theory. Are you doing any of the practical, John Paul?
I believe they get to do a mediation where they
Okay.
play the mediators and they play their respective parties. So
Okay.
they do have a mix of it, but it's a pretty short course.
Okay. Yeah, Vivian, it would not hurt at all to do the program, and I think you'll learn a lot from it. I'm still in touch with some of the people that were in my program, and I think it's money well spent. Like, I wouldn't suggest you go off to Harvard and do the project on negotiation. One of my former colleagues, he didn't. I asked him, should I pursue this? And he said no. If your firm or your employer is willing to pay for it, great. But that might be that's a bit expensive to do, because you have to go down. I don't even think they're running it right now. And would you really want to go down to Boston right now and be at a mini super spreader, at Harvard? But there are a bunch of good programs that are available, and I'd recommend that you do it, Vivian, if you're interested in switching over to mediation yourself. It cannot hurt. Adam, how do you prevent exposing your position or strategy in case the other party is exploring for trial? I assume that means as counsel. It's going to come out eventually what your strategy for trial is, and one of the notes that I made and forgot to mention when I was talking about the role and value of mediation is the program that I took, which was at York University. The biggest lesson that wasn't part of the curriculum was the way that you can get the best result for your client is preparation. So I think a question earlier on was, that you had, John Paul, or more of a statement maybe was, where parties treat a mediation as trial. Well, if you're prepared at mediation with your trial strategy, if you're prepared at mediation with the evidence and the witnesses that you're going to present at trial, you're in a very strong position. If you are if you're organized and you can say, okay, this is our theory of the case, and these are the witnesses we're going to call, that's kind of scary for the opposing side, because it shows you've done your homework, you've already prepared your BATNA and your WATNA, like you know what's going on, like you really know your file, and that I don't think you need to hold your cards back, and to use another poker analogy, hold your cards close to your chest. If there's any time to show your hand, and I apologize for all the metaphors, it's at mediation. Like, this is your opportunity to speak to the decision maker on the other side, and it'll scare the hell out of your opposing counsel or your opposing representative, showing how organized you are. How do you deal best with age-related issues? Could you clarify that, please?
I think maybe it was coming from our discussion about
technology.
Zoom, I guess, yeah.
Okay, all right. So the best way is just to get them on. Oh, sorry. All right, in virtual meetings, technology. If they can't get on, if you can't get them on Zoom, get them on the phone. Conference call them in with their client. Most counsel will have some support staff that, if you and I are mediating, John Paul, and your client's having difficulty getting onto Zoom, you get your assistant, your clerk, a colleague, get them on the phone, walk them through it, try and get them on Zoom if you can, and if not, you just continue on with the conference call and do your best. I've had mediations where Zoom just died, in the sense of like one party, it just quit on them. Maybe they're having a connection issue with their internet. You just get them on the phone. You do what you can. You just got to continue communicating with them. Mediation in person is great. Mediation over Zoom is okay to good, but it doesn't mean that you can't negotiate if you're not seeing them. So early on when this started, a colleague and friend of mine named Robert Bazunder, he's a lawyer and mediator, he said in a LinkedIn post, you don't have to use the technology. You can still just get on the phone and talk to somebody.
Now, with mediation, what maybe do you have any? I mean, obviously, you can't share sort of really specifics, but any interesting anecdotes about what could go wrong at mediation that I think maybe reassure some of the students who have these mock mediations that they have to do, like that to be. Don't worry, there's been some other situations, so you're not gonna have to deal with. Maybe you can share something to kind of reassure their nerves.
About what can go wrong, or what surprising things happen?
Yeah, surprising things. What could go wrong? What you've seen in your years there as a mediator, or on both sides there?
Well, you kind of caught me out there, John Paul. I'm not really sure. I think bad surprises come from a lack of preparation. Not to say that you over prepare, but if you've got a given set of facts, know what be sure that you know the facts that you have. Be sure that you know your evidence. Oftentimes that bad behavior that you sometimes see between parties is because of a lack of organization, a lack of preparation. I had one guy who started off the mediation essentially just yelling across the table when he was confronted with facts that he hadn't prepared himself for his client for. He didn't know the file. He was talking about his client, got her age wrong, got what she did for a living wrong, talked about the wrong injuries. He didn't know his case. That's awful. You got to be prepared. And that doesn't mean, there's a fine line between preparation and over preparation. But, know your facts, know the evidence that you have, and don't misstate it. Surprising things at mediation, I've come to learn that you don't assume that a case is going to fail at mediation, and you don't assume that the case is going to settle. Mediations that I thought were definitely going to result in a resolution have not. Some where I thought there's no way we're going to resolve this, we're just going to do our openings and then it's going to fail because one side is going to say it's unreasonable, and they settle. As whether you're mediating or whether you're advocating for a client, I think you go into mediation with an open mind and be prepared. Maybe it's an oxymoron, but be prepared for the unexpected. You kind of got to roll with things to a certain degree. And I had a point that went on in one ear and out the other, but maybe I'll come back to it. Darka has another question. Do you find there is more or less agreement on video, audio? If you could clarify, do you mean as opposed to in person versus between video or audio? Maybe even before Darka responds, I don't think there's a different success rate. Okay, between video and audio. I don't think there's a different success rate, whether it's in person or virtual or video or audio. I don't have enough of a sample size to give you a statistical analysis on that. And um, the first one I had where the plaintiff came in just on audio, that one didn't settle, but that was really, I think, because of what was going on in the negotiations and the offers, not having to do with the technology. Like the technology, like back when I first started mediating, or sorry, when I started practicing, fax machines were common. I can't remember the last time I sent a fax. Email was in its infancy, and people were concerned about whether or not you could use emails for legal communications. Now, I send everything by email, and during the pandemic, I'm avoiding sending mail because it means that a letter carrier has to deal with my mail. Someone at an office has to open that mail and process it. Like, don't be concerned about the medium. Be concerned about, oh, this is corny. Be concerned about the message and getting the message across. It's important to keep communicating, not so much about how you do it. But the way that you're interacting can make a difference between understanding the dynamic. So being able to see John Paul smiling when I say something means that the message is getting across. And unfortunately, I'm not seeing many faces in this, but so I don't know if my jokes are landing dead or not. And humor doesn't do well on the internet. So
that's the biggest thing from teaching online, I can say, is that maybe it wasn't funny to begin with, but at least you can see some smiles and laughter in the classroom, but you don't necessarily get that, and then you're kind of maybe laughing at your own jokes there to get through those awkward pauses. But what about you mentioned continuing communication there. Do you see mediation where it's more than a one-off, that you have like a follow-up session, or is it purely like a one-off basis?
When I was practicing, I rarely got a follow-up from a mediator. And there was a mediator that became my favorite mediator because he followed up. It was, I mentioned it before, it was the lady who we found out had cancer. In that file, for a host of reasons, it did not settle at mediation. It did not settle within a few months of the mediation. And we went to a pretrial conference, and the mediator had asked, when we were in the session, could you let me know when your mediation or when your pretrial conference is? And a week after the pretrial, we started phoning around to everyone and asking, how did the pretrial go? Is there anything I can do to help? And so what I've been offered, and because of, I think because he interjected himself, because he started communicating with us, I think he made the difference between that matter settling and us going to trial, which would have been a disaster, I think, for everyone. And so what I've been doing is, if the parties can't resolve their matter at mediation, I follow up, or at the very least, I invite them. If you think I can be of assistance in the future in continuing your negotiations, or in a continued session, let me know. I'm glad to help. And I don't charge for it, but I think it makes a difference, because something I said earlier about what's going on in caucus, it is easier for a party or an advocate to say something to the mediator in private that can then be filtered and then expressed to the other room. It's kind of hard for me to say to John Paul, your client's case really sucks. And here's why. You may get your back up, John Paul. You may get really upset. I'm saying something in front of your client that suggests that you're not doing a great job, or that you've missed something, or maybe you have not had that hard discussion with your client about the strengths and weaknesses of their case. The plaintiff's never had a reality check. It may be easier to do that through me. Here's the defense counsel's concern about your case. Doing it that way, that it's sometimes easier to use the foil a neutral third party to get something across. So I keep asking if that makes sense, but hopefully it makes sense. And now Chris has a very lengthy question. All right. A phone call to the other side. So if you're being met by a hostage, like I assume that what you mean, Chris, is early on when you're dealing with another side, the other side in a dispute, and you give them a call. If you're being met by hostility, when you're just asking a question, trying to gauge where things are going, that speaks more to them, I think, than you. It's very effective advocacy, I think, for your client to reach out early. It's like, if I get a new file, like how things typically work in insurance defense is I will get a new file referral from an insurance company, and I won't have much because the adjuster, the insurance company, probably doesn't have too much. My first, after doing a very brief assessment based on what materials have been provided, I'd send that letter to the adjuster, and then I'd send a letter out to counsel saying, hey, I'm new to this file. I've been assigned as counsel. Here are the documents that I'd like to see. Can we set up a phone call to talk about the case? Can we set up examinations for discovery? Can we set up a timetable for when you're going to provide me with your affidavit of documents? Getting things going. I don't see any reason why you should not be having a conversation early on with the other side, with the representative of the other side, to get the ball rolling. All your communications don't have to just be through letters and emails. A lot can be done very quickly with a phone call. All right, so Chris agrees with me. Good. So yeah, it speaks more to them, Chris, than you. Rochelle has a question for me. What special considerations exist in interviewing witnesses who do not speak English well? Hopefully they have an interpreter. I'm not sure if what you mean, Rochelle, is in dealing with parties as a mediator, or dealing with a person whose English is where someone's having difficulty with English as your client. But either way, you need to be able to properly communicate with them. And if you have a party who's come to a mediation and their English isn't, if you're having difficulties communicating to them in English, and that's the only language that I'd feel comfortable communicating with someone in this context, how is counsel going to be able to get, how is counsel or their representative going to be able to get meaningful instructions from their client if there's a problem with communication? Practically, don't use legal jargon. Don't use the big words. Use simple concepts, simple words. And if there's any concern that they do not understand, you need to get an interpreter. And in the context of a mediation, if a party is not able to communicate, if they're not able to understand, then their lawyer is going to have difficulties getting instructions that are enforceable. Like it's an ethical and errors and omissions nightmare. Like if your client later says that they didn't understand what they were agreeing to and what they signed for, oh, very bad. It's very bad for you.
Perfect. So just I want to check if there's any last questions here before we wrap up here. And I have maybe one last question here for you, Andrew.
I'm all ears.
So thank you so much for joining. It was very insightful, and I think hopefully it was a perfect preparation. I think Christopher's maybe really happy because he's got his students ready for their exam tomorrow. They got a lot of good information. A lot of it touched on everything in the course, which is always great when things about focusing on preparation and all of those main points that got brought in and really illustrated with real practical experience from people like yourself there that we really benefit. I think from the education standpoint, having speakers come in like this, like yourself, something we would never have been really able to do otherwise in person. So there's advantages, in other areas that we're really happy with. And so perhaps maybe you can share some final words of advice. We have at least a couple students interested in getting into mediation for students either in getting to become mediators. What advice maybe you could offer for them, or in advocacy before a mediator? Maybe you can wrap up with that. Thank you so much, Andrew.
Oh boy, you ended it with a question that could take a half hour, 45 minutes. If you want to become a mediator, I think you have to, oh boy, I may not be the person to give that advice, John Paul. I'll say what I mentioned earlier in response to, I think, Vivian's question about whether she should take the course. I think if you're considering it, taking a course like that, like the one at York University, and there are others in the GTA, and I'm going to assume that most of your student body is here in the GTA or nearby. Take a course, because it's a relatively small investment to figure out if you'll like it. And if you're doing a practical mediation scenario and you don't like it, imagine how much worse it's going to be when you've got, paying customers who, aren't just your classmates who are trying to work through a scenario, and it's real life. If you're not enjoying the course, you're probably not going to enjoy the practice. And in terms of advocating in front of a mediator, I think it goes back to what I mentioned earlier, which is preparation. And part of that preparation, I think, is having a concise, well thought out brief that provides a roadmap for the adjuster, for the mediator, about what's at issue, what is the evidence that you're relying on, and where you see the different heads of damages, if it's that kind of a case. Like, you have to give me a break here. You got to give me a proper picture of what your case is. And if you don't put something into your brief that is important, then you're going to be spending more time trying to explain it to me. It's all I get. It's really how I base my ability to help you as an advocate, as a mediator, is what you've provided me. And then when it comes to the actual mediation, prepare your client. It's one thing to be prepared yourself as an advocate, as a representative, but if your client doesn't understand what they're getting into, what the purpose of the mediation is, and what's going to happen, there's only so much I can do in the limited period of time that I have at your mediation.
Perfect. So thank you so much again, Andrew, for joining. And if anyone wants to connect with you, sir, anyway, they can reach out to you.
Well, I've got a website, www.clarkemediation.ca. But feel free. It may take me a little bit of time to get back to you. I had one other point, but it's gone in one ear again and out the other. But if you want to invite me back in the future, feel free. I'd be happy to do that. Unless there are any other questions from the chat, or if anyone wants to show me their face and ask out loud, thank you so much for having me.
Perfect. All the best, and take care, Andrew.
Thank you. Everyone take care, and good luck in your exam tomorrow.
Thank you, Andrew.
Thank you so much, Andrew.
You're welcome.
Thanks.